Am I audible?
Good morning, everyone. I, Vatsal Chaudhary, teaching associate from School of Law, Starex University, Gurugram, welcome you all to the morning session of fifth day, that is second last day of International Faculty Program organized by Starex University, Gurugram, on Advanced Research Methodology in New Emerging Trends and Technology, a Social Legal Approach. During the last 4 days, we all have gained a lot in terms of knowledge from various legal luminaries from different parts of our country. From here on, our program goes international as the honorable speaker for this session is a renowned legal academician from Maldives. Let me introduce you all to Mr. Mohammed Imran. Mr. Mohammed Imran is lecturer of Public International Law at Faculty of Sharia and Law, Villa College, Maldives. He also teaches international contracts and international law and institutions to students enrolled in LLB and LLM program offered by University of West of England, Bristol. He completed his LLM from South Asian University, New Delhi, and BLLB honors from Aligarh Muslim University. He has served as student reporter and the chairperson of editorial committee at Section for Law Students, Indian National Bar Association. He had been very active in his faculty and was a member of Law Society and Secretary of Law Society. He has got several articles published in reputed law journals such as Asian Journal of International Law, Indian Bar Review, IUP Law Review, etc. He also co-edited books like Access to Justice, Need for Reforms, published by Faculty of Law, AMU Murshidabad Center, and Technology-Based Violence Against Women, published by RIGI publication as a project with Kal Ki Soch. He has a deep interest in legal and social work, and his areas of interest include international law, parliamentary studies, election law, constitutional law, jurisprudence, etc. I would like to share a small fact with you all that I and Mohammed Imran share the same alma mater, that is Faculty of Law, Aligarh Muslim University. Today, Mr. Imran will be speaking on research methods in international law. Over to you, Mr. Imran.
Thank you, Vatsal, for your kind introduction. So before I start, I just want to thank everyone from the Starex University School of Law for inviting me, Vice Chancellors, Dean and HODs for organizing this wonderful event, especially giving a chance to someone like me who is comparatively younger. So I hope I would try to justify my presence here in this event. So let me share my screen, I think. Yeah. Right, so I can see we have more than 50 people currently present here, more than 60. So we'll try to make it more of interactive. I will not try to make it boring, as I know that most of the topics must have been covered by the previous speakers in the last 3 to 4 days. So before we go with this research methods in international, anyone who can recognize this picture and this PPT? Just take a while guess. You can note this picture, you can maybe take a photo, and at the end we can discuss why this photo is really important so that we can save our time. All right, I think I can move on. So here is our agenda for today. So, you know, international law is a huge area of subject, and it's also legal research, so there are a lot of things that we can discuss. But given the paucity of time, I have to summarize it. So I'll keep our focus to the framing of research question and primary and secondary sources within international law framework, not necessarily how we do a legal research in domestic sense, and things that are very basic while doing a research in the field of international law. Now, I know you must have come across things like research question, hypothesis, and all. But broadly, in international law, we can divide the research question in 3 categories. Of course, this is not the best category that we can define, but most of the things would fall within these 3 categories broadly. The first one is descriptive question. These are questions about the state of things as they are. And most of the traditional research in the international law field are done on the basis of descriptive questions. For example, let's say you can talk. Am I audible?
Yes, sir, you are audible.
Okay. So the idea is this: most of the traditional international legal scholarship has been descriptive, in a sense that it tries to describe even those who do study in the history of international law, or those who do study in the international criminal law, or let's say trade or investment law. They would try to come up with the idea that this is the convention that the parties have signed, and therefore the parties must abide by the convention rules in good faith and so on. Then, of course, there may be some nitty-gritties with reference to whether it is a soft law or hard law. But idea is that once the states have taken certain obligations, they are supposed to follow. We can take, for example, Anthea Roberts' books. She asked in her book whether international law is truly international. And for this, she looks into the different parts of the world, for example, India, China, US, and other European countries, how they domestically practice international law. So with reference to China, she says that Chinese courts quote more international law cases or principles compared to United States of America. Whether we know that in the US, as per their own constitution, international law, which has been, international conventions, which has been approved by the Congress, becomes directly part of their domestic legal system. So there are different parts of the world who they follow the monist and the dualist theory, and exposition of these kind of ideas may fall in the descriptive research question. And what you can see that there is no critical analysis necessarily. You just describe what is happening on the ground. The second kind of research question that you can have is normative research question. And in this, the scholars or researchers would try to ask what law should be there, whether be it gender or specific. Again, we can take one example. For example, there's this book, The Dispensable Lives of Soldiers by Gabriel Bloom, who asks what should be the rules for targeting of combatants in armed conflict. In India or in South Asia, Asian reference, we can have, let's say, how to protect refugees or how to protect your borders from illegal migration, right? Whether the existing international legal framework is good enough to protect the refugees who are victims of forced migration and so on, right? So if you try to see the international convention, this refugee convention or the statelessness convention, they don't necessarily protect a person who is still in his country and he is stateless until unless the state is party to that convention. And more problematic is that the refugee conventions try to protect people who are victim of certain kinds of discrimination. For example, if you are a victim of, let's say, climate change, and you are forced to leave your country or move on with another part of the country, you may not be considered as a what we call as a climate refugee. That is an expression, but that is not a legal expression. One of the difficulties in this normative research question that tries to, let's say, adjudge a matter of international law is that you need to have a theory or you need to have a point of view to understand it. For example, if you know about, everyone knows Professor B.S. Chimney. So he's one of the greatest scholars of international law we have, fortunately. So he's also a scholar of third world approaches to international law. And B.S. Chimney and other 12 scholars try to tell us how the colonialism still continues in terms of international law, right? So for this, they came up with separate approach we call as third world approach to international. The idea is this: in normative research, you need to have some kind of perspective or some kind of theory. Someone can have feminist approaches. You can have, let's say, Marxist approaches, positivist, or anything else. Within this normative, you can also have the third, and which is the most important right now going on, is the critical approaches. So critical research question. Those who work in the areas of critical research would try to inquire or expose the power relation that shapes the law into the relationship between law and politics. For example, how law is actually shaping the politics, or vice versa, like how politics is shaping the law, in a sense that those who are already in the powerful position are capable of making the law that benefits them. Again, Martikoskienemy, or let's say we have example of Anthony Engie. Both are scholars of history of international law. So Anthony Engie in his book asks how colonialism shaped the origins of international law on the basis of this post-colonial theory, like third world approaches to international law. So these are three major approaches in international that you can have. So let's say if you're doing a research on international trade or investment law, the best way, if you don't want to work theoretical concept, you can go with the descriptive. But if you, let's say, want to say that the way in world WTO dispute settlement works is problematic for the third world countries, because US has huge investment in the WTO, and US actually controls the dispute settlement. For those who are aware of the controversy that US stopped the funding of WTO because lots of cases, it was losing a lot of cases in WTO dispute settlement. Similarly, you can take the example of International Criminal Court. When an investigation was supposed to be launched by ICC in Iraq for the war crimes against NATO and US actually sanctioned judges of the International Criminal Court, which is very rare. So if you're doing a critical research, you may try to see how these laws are helping those people who are already in power. For example, African leaders argue that those people who have been convicted yet in the International Criminal Court, all are Africans. So this entire international criminal law is based on or being experimented on the people of particular race, which is not so good, right? So apart from these three research questions, or three types of research question, what is more important for us is how to approach for primary or secondary data. In domestic law, of course, the approach is different, but I believe that we may have some different approaches, and most problematic part is how to find relevant primary and secondary data. So we'll come to that, but let's understand why we need to do that. So we know that international law is similar as well as different from the domestic law. Similarity because we need to have a research question, and we also need to understand that the problem that we are approaching, whether it is the problem of refugee law, it is the problem of statelessness, or it is the problem of, let's say, third world countries losing lots of money in international investment cases. For example, India lost huge amount of money in Vodafone versus India arbitration, everyone knows in India. Or for example, in Maldives has lost almost every case against the foreign investors, whatever it ever had. So you can try to expose why this is happening, whether it is the domestic problem of these countries or whether it is the way arbitration and the investment law has been working. For example, if I remember correctly, India's law minister, Mr. Ravi Shankar, he was speaking in parliament. He said that he was actually quoting cases from Latin American countries and African countries where the European and American country would come and make a promise to, let's say, invest $50 million US, and after investing $10 to $25 million, they would come up with certain legal issues and would go to international arbitration, and they will sue the country, right? So it will become an investor-state dispute. But that is these countries may not be fully equipped to tackle lots of cases in different jurisdictions under different laws, and therefore they end up losing the cases, right? So the burden of these countries keeps on increasing. Therefore, we have in 2014 we have new India's bilateral investment treaty model. So yes, we need to know the problem, and also we need to answer the method to answer your question. For example, whether it is a particular approach, it is doctrinal, or whether it is critical studies, or whether you are talking from feminist perspective, whatever you are. And similarity is also that you need to rely on both primary and secondary sources. Now, the difference is more important than the similarities, and one of the most problematic aspects of international law, as you must be knowing, is that international law is considered universal, and it is practiced almost everywhere. And this is the biggest problem of international, that it is practiced everywhere, and therefore every person or every country for that matter has its own perspective. So you can take Europe. Most of the countries, for them, international law is the part of their domestic system. And there is reason, because during the entire time when the colonialism was there around the world, they developed these theories. So they know how things work for them, and therefore it may be easy. But for many countries like India, we need to come up with certain protections so that we do not again fall in the same kind of way just because we have signed one document. So as I said, although it is practiced everywhere, there are some different approaches by different countries. Also, international law is not hierarchical. We know the famous debate of John Austin, who says that international law is law of positive morality, because it says that there is no ultimate sovereign in international lawmaking. So there is no hierarchy. So several frameworks can try to cover the same issues, both from the soft law perspective and also from hard law perspective. And you will find that there are important problems which are not covered by the hard law convention. For example, let's say if India violates TRIPS agreement, there will be a country that can go to WTO dispute settlement and can file case, or the Vodafone case that we had recently. But if any country in the world violates human rights, there will be few resolutions and convention. In fact, even after committing genocide, there will be just small investigation, then direct case in any dispute settlement body, because idea is that most of the human rights issues are superseded by the idea of sovereign. So sovereign is always more powerful than the quote-unquote idea of humanitarianism. So this comes with the idea of fragmentations. And lastly, the international law source include customary international law. And customary international law has one of its own problem. For example, we know that there are several customary international. For example, countries cannot commit genocide if it falls in the definition of genocide convention. So prohibition against genocide, prohibition against torture is considered as erga omnes obligation, means against every country. Or for example, diplomats have their immunity, head of states have their immunity. But then there is a problem with this idea of customary international law, and I believe you can relate to this. Most of these theories, customary international law, be it, let's say, Cannon Short tool or any the immunities of these diplomats or head of state, or any other custom that you see, they developed during the colonial period, right? And it means the countries that we see today as independent members of independent states of UN, they did not contribute to the making of custom. But what is more problematic is that they never got the chance to oppose the custom, right? So this idea that you become consistent objector to a custom only if you can object when the custom is being framed or being developed. But most of these countries that we see in Asia and Africa, they got independence in 1950s and so on. So these countries never got this chance to object to any custom that is made by European states. So there is always some kind of problem with the customary international also. So when you apply customary international, try to maybe add something else along with the idea that the custom is binding on almost every state. Okay, so as I mentioned that in international law, we have primary and secondary data, but then there are also challenges to doing research in international law with these same resources that you also use in the domestic law. One of the biggest problem in international law is language barrier. I know most of the research in our region in international law is done in English, but if let's say you want to do a research on the very concept of freedom of sea that Hugo Grotius wrote, and there are commentaries translated in English, but who knows what actually was said in the original book that was written in Dutch, I believe, or you cannot read, right? So there is always a language barrier, because there are scholars who wrote a lot in German language. Then the dominant empires before the British became one of the biggest empires in the world were the Spaniards, the Spanish people, and the Portuguese. So they have developed a lot of international law before British became one of the main, biggest empire in the world. So the classic international law that we talk about was not developed by English. So we have our own limitation, which creates another problem. Sometimes we may try to limit our let's say research on a particular timeline. For example, if I'm doing a research on the, let's say, historiography of international law in India between 15 to 17 or 18th century, which is basically the fight between native kings and Mughal and the British East India Company. If you try to look into the Mughal archives, they were written in Persian language. So there are another problem. Or if you go to study about the ancient Indian kingdoms before any Muslim king or queen ever came to India, they were written either in Pali language or maybe Sanskrit or maybe in older version of the Tamil or Malayalam language. So the idea is that whatever kind of research you're doing in international law, there may be a time when language may become a barrier. Then you have different approaches. As I mentioned, it may be critical approaches or New Haven School. And when we read a book, as a researcher, initially, we don't even think about the approach that the author has taken. So for example, let's say you are reading a book of Professor B.S. Chimney, who is a post-colonial scholar from Global South. His approach is either Marxist or third world approaches to international, which is similar to Marxist approaches. Now, if you're reading him, you need to have this basic idea that he is seeing the international from a particular perspective. Similarly, if you read the scholarship based by US scholarship or written by US scholar, their approach towards international law will be of policy. It would look like they are trying to make a policy to regulate the entire world or something. This is called New Haven School. If you see other European scholarship, it would look like it's a more of a positivist approach, because for them, most of the international law is part of their domestic system. So they never differentiated between the international law and the domestic law as such. Now, the idea is this: you can read the article from US, let's say New Haven, Marxist approach or positivist approach on the very same topic. Maybe the title may be a little bit similar, but the problem is that we may not realize initially that these different authors have referred or approached the same problem from a very different legal perspective. So whenever we read, we need to have an idea that one perspective cannot give the clear picture. So we may need to have another approach just to get an idea, or an opposite idea just to be more neutral to our own writing. Okay, and within each culture, okay, I think there's, Just give me 1 minute. I think my battery is low. Just give me 1 minute. Apologies. We are done. Okay, so now apart from these different legal approaches, these are just 3, but there are more to it. Specifically, feminist scholarship, feminist approach is one of the most important approach someone can look up. But then within each approach or within any legal culture, there are different camps. There are different ideas that is going on, and people can write from a perspective even without being associated with a particular approaches to international law. For example, if you see the point number 2, people who are affiliated with the state institutions, they might interpret law in a manner which is more permissive of the state action, while others who may not be working with the state government may be suspicious of the actions of the state, and they would try to restrict the involvement of the state in the matters that may think be abusive to the citizens or the people who are subject to that particular law. We can take, for example, David Luban's idea of international humanitarian law. He says that there are 2 interpretations of IHL. One is the military, and another is the humanitarian lawyers approach. So those who take the military approach, they would try to argue that the security is more important than maybe a little bit of violation of IHL or maybe human rights. But those who would try to take humanitarian approach, they would argue that in any case, people who are not active combatants, people who are not combatants, or maybe they may be doctors, journalists, or civilians, they should not be targeted or killed, and the target should be specific to the person who are actually involved in the war. These kind of comparison we can also find in the international trade law, investment and arbitration, and environmental law. In investment and trade, we can find more than the IHL and human rights. The reason is that trade and investment is in the interest of each and every state. So their own documents, their own reports you can read, and you would find this comparative idea that those who are working from the state's perspective, for example, if you are in India, you can read Dr. Prabhas Ranjan's articles. He always writes on different newspapers also, and basically on Indian Express and the Hindu. But he's a very renowned scholar of international investment law in South Asia. So he has been very critical of India's approach to Vodafone case, right? He believed that India could have easily handled this particular case without going to international arbitration. But if you read the government's report, or those who are still part of, let's say, ministry, and they are writing some opinion in the newspaper, their approach would be that Indian government's approach was better, although we lost the case. So when you read the idea that when you read some article or any resource, be it secondary, if you have an idea how the author is actually approaching, you know the reason why he is approaching, that will be better for you to incorporate his ideas into your own paper, into your own research, right? So just get an idea of what camp is that our author belongs to. And also in the secondary sources, if we are aware of the critical if we are aware of the hierarchies and we are critical of it, it will be very good for our research, especially from our part of the world, because as I mentioned, we didn't contribute a lot in the making of international law. So we have to be a little bit suspicious with reference to theories. So let's, for example, we know that most of the classic books on international law were written by white Western men, and they wrote these international law books, treatise from a certain perspective. For example, those who are reading international law, latest editions of, let's say, Emin Shaw or Akhirist, they would know now they have added Vittoria, and there is debate that now Vittoria, who was Spanish scholar, was the father of international law and not the Hugo Grotius. But if you read their ideas, Vittoria's or Hugo Grotius, they always talk in a way that the native people, let's say Native America, where Christopher Columbus reached on behalf of Spain, they may have human right, but they don't have sovereign right to rule their own, their own land, right? So the idea is this: when we read these classic books, we need to have this critical approach to their writing. Otherwise, it would look like we are taking their ideas, their concepts or theories as a positive law in our writing, which may again dilute the whole work that we are trying to do, right? A better way to go through the latest updates or latest edition of different book. For example, if you're reading about the classic international law, Oppenheim's first edition and the latest edition may have different approaches with different ideas. For example, who are the subjects of international law? In India, we always study that the first edition definition did not include individuals and international organization, but the 9th edition, I believe, did the individuals and international organization, right? So the latest update or a comparative study of the first edition and the latest edition of these classic treatises may be also helpful, so that we have a particular idea of the hierarchy. Sometimes a book review, a critical review of this classic commentary is more helpful than reading the different books of different edition. Now, this is one of the most complicated problem you may come across while doing a research in international law, because let's say when you're writing about Indian Constitution and you study in Indian law school, you know the big names. For example, maybe MP Jain, H.M. Shirvai, Professor Upendra Bakshi, and there are some great lawyers we had. And then currently we have Gautam Bhatia, for example. So these are our scholars that we roughly know. And these are also the competitors, right, when you write on the same issue. But when we write about international law, you are actually competing with the whole world, right? From someone writing in Germany or someone writing from a small country, someone, let's say, writing from a country which is a landlocked country, but person is writing on a topic of law of sea, and he has his own sense of how the law of sea works, right? And someone is writing in a country which country is completely an island country, so they may have their own sense of how the law of sea may work. In this sense, one need to understand the important writings on a topic that you are doing a research. It is not a very perfect example, but Google Scholar can actually help you in knowing who are the perfect scholar, not necessarily perfect scholar, or the perfect writings or important writings, in a sense that Google is going to provide the citation. So let's say if you're doing a research on India's approaches to use of force, right? So if you use India and use of force on Google Scholar, there will be multiple articles that you can see, and you can also see their own citation, how many people have cited their work. So based on that number of citation, you can guess an idea that these are important articles. But again, there is the problem with this kind of approach is this, that we don't know how Google books, they target someone's articles, how someone's article comes on the top, because it's based on algorithms. So there may be different issues, maybe more technical, that I don't know. The easiest way that I found, apart from Google Scholar, is that you can try to look up at Max Planck Encyclopedia of International Law or Oxford Bibliography of International Law. Max Planck may not be available without access, the paid access, but this Oxford Bibliographies of International Law, it is usually accessible without any kind of subscription. So let's say if you want to do a research on reparations under international law, you go to this website and you can simply search reparations and the bibliography will give you the basic idea of most important writings done on the reparation. For example, you can take another topics, let's say fair and equitable treatments under WTO CAT agreements. So apart from this, a Max Planck or Oxford bibliography, the idea is that you will get a central view on the topic that you are doing a research. But again, there will be challenges with Max Planck also and this Oxford bibliography. And the challenge, or maybe with the Google Scholar, is that these are for the countries or people who have a lot of resources and they can upload each and every article online. They can make it available there. Therefore, their article is being read. In other parts of the world, for example, in India, we have several journals, reputed journals, for example, Indian Bar Review, they don't publish it online. So even if you have written a good article on a very important topic, a student who is new to that area may not know about your article because that article is not available online, or for that matter, anywhere to search, right? So whenever you read about any particular geographical or racial or any other kind of hierarchy, try to be critical of that. I'm not saying that they are bad, that therefore you have to be critical. Critical because you need to challenge the existing idea at some point of time, but you may also agree for the ideas that you think are, at par your own views. Apart from these resources, you may try to go the neutral search engines such as Hein Online, Westlaw, maybe JSTOR. They help you because there is no hierarchy, like there is no top read articles as such. When you search, they search your article based on the keywords you provide. So whenever you try to search any article on Hein Online or JSTOR, don't search a question. For example, who are the important scholars in let's say, history of international law? It may be more scholars and history and international law. So they just search based on the keywords that you provide. The more radical way to do a research and find a more neutral perspective or an article is to actually physically visiting a library, right? So let's say if you are in Delhi, you know that for international law, Indian Society of International Law has really good articles. ILI has really good articles. You may want to visit maybe Jindal's library, or one can go to South Asian University's library because they do all the research on international law. The idea is this: you can find several articles that you cannot otherwise access online. For example, if you are writing about how British created their own sovereignty in India, you may want to go and read articles edited by Professor Alexandrovich in 1952-52 edition of Indian Yearbook of International Affairs, and those books are not available online. The later versions are available, so you have to go to ISIL library, right? So the idea is that only online search may not be enough, but again, it depends on the kind of research you're doing. If you're writing a blog, maybe initial articles, so you don't have to do this much of labor, but maybe for dissertations and thesis, this may be really helpful. Now, apart from those approaches to secondary sources of international law, we have primary sources, and we know that Article 38 of ICJ statutes mentions that there are different sources. First is the international conventions, then custom. Third one is the general principles of international law. Just to remind, the general principles of, actually they are general principles of law, they are not of international law. So the general principles of law practiced by civilized nation, they're actually the principles of domestic law, right? So like no one can become judge in its own case, or let's say law of estoppel, or law related against law related to usurpation of new territories or something. The idea is this: if these are considered as the primary source, you may be sometimes confused regarding how one source may be considered as primary. You know that cases, judgments of international courts and domestic courts, statutes, conventions are considered as primary source. But let's say you are trying to work on let's say Kelson's idea of pure theory. You are doing a particular research on the pure theory, right? And you just refer to his book, Pure Theory of Law. In that case, your primary source is actually Kelson's book, right? So there is this problematic aspect. But again, within these statutes or resolutions, you may try to see that there are resolutions passed by some international organizations that are not exclusively known for making laws, like UN or ICRC, and they may not be binding within the countries. They may be just enforceable otherwise, or maybe just a statement, right? So try to exclude them, otherwise there may be some problems. So try to stick to conventions or resolutions that where the states are actually parties and not the representative or informal representatives of the states. The idea again that not everyone may subscribe to this ICJ's hierarchy, right? That the first convention is the best source. Let's say if you're doing a comparative or some kind of empirical research on the approach of International Court of Justice to the matters of land related to third world countries, the primary source will be judgments, and then judgments are considered as the subsidiary means of interpretation or subsidiary sources under ICJ statutes. So there may be these kind of issues, but from legal realist perspective, whatever is considered by or perceived by the international actors, which are the states, as authoritative in a very specific case, they can be considered as relevant, and sometimes they may be considered as primary sources. Okay, so this enough about the technicalities. This may be interesting for everyone. So if you are doing a research on international law, the most important source for primary sources is international legal materials published by American Society of International Law. The best part is that it also provides a comparative material. For example, if you are reading about, let's say, forced migration, when you search, you will find that the forced migration issues or the laws made by UN or made by any, let's say, Human Rights Commission or made by European Union, they'll provide the entire list of different bodies. So that may be helpful. One of the other way to find primary sources such as international treaties is to go through UN treaty collections. There is a different website called treaty.un.org and something. So it provides the entire original copy of the treaties that have ever been, accepted by the UN or for that matter, League of Nations. There may be some treaties which are not part of UN or League of Nations, or they are somehow not registered with their secretariat. For that, you want to look at Oxford Historical Treatise. And then also you can also visit with reference to investment or trade law, WTO's website. Their website is too rich to do a research. You can write an entire thesis on international trade issues just by visiting WTO's website. ICRC, we know, is infamous for writing or working on the field of international humanitarian law. This Starex preparators are the documents of the negotiations of international treaties, their history. These are similar to what we understand in Indian case, like the Constituent Assembly documents, right? So the documents of Constituent Assembly proceedings are always available online on the Parliament's website. Similar to that is the Starex preparatory. You may also look on UN's library website to know about other topics or emerging areas or some old collections of international law. Now, for judicial decision, we know we can go to ICJ's or website, or let's say International Tribunal for the Law of Sea or European Convention of Human Rights website. Every website has its own set of laws. But sometimes it may be difficult. For example, if you want to know about how the European Commission has approached the issues related to abortion, and how African Court of Human Rights are approached, and how American Court of Human Rights approach. You have to individually visit their website, and they may not have enough, interactive options to do a lot of search. So Oxford Reports on International Law is another more interactive website where you can find cases based on the topics that you want to search. Similar to Oxford Report, we have Cambridge Law Reports. They are similar to what we have in India, like Manupatra or SCC Online. Okay, now for the UN documents, there is a website called un.org. So UN's, and there is also a separate website called the UN's Official Document System. We have UN Library. These libraries or the document system will provide overall documents of any committee or any organ of UN on their website. But otherwise, you can also visit to different organs' website. For example, the UN Security Council website. You can find their resolutions, statements, or record of the meetings, or any other document related to maybe sanctions. Similarly, you can visit to General Assembly's website of United Nations or any other organ like Human Rights Council. Idea of mentioning these primary sources that sometimes we read in an article, we try to quote from there only. Reading original document is very, very important. When I was in Delhi during LM, I visited ILI and I met Professor Manoj Kumar. He was speaking in an event in ILI. So he told me how reading the secondary, sources for a topic which is of primary concern. For example, reading about what was said in a particular sanction, put by United Nations Security Council in original language is something different from what an author can try to read, because they have their own approaches, they have their own methods. So they would try to take the portion which is relevant for them. So this is precisely all. I know I kept it very short, but I believe we can have more questions. And once we have done with the question, I have few things to share, but maybe first we can have some questions.
Thank you so much, sir. That was a great session. And thank you so much for sharing your valuable time and knowledge with us. I'm Divya Sharma, Assistant Professor at Starex University, and I'm going to moderate the question answer session. The question is asked by Ms. Neetu, and her question is that during research on agreements of WTO or discussing the case settled by DSU, can we use the meeting or panel or appellate body, reports or documents, and do interpretation, or we have to refer or cite other books, authors also?
Yeah, that is what I was mentioning at the very last point. It's good to refer to a book and something, but if you know that the document is easily available online, publicly available, it's better to go and read once, right? It's not only about the matter of citing, it's also when you write your article, although by citing, you are actually providing your own opinion about the same document. So reading original document may give you a certain perspective that I think the previous author from where you are trying to cite may not have. But otherwise, for the purpose of citing, it's not problematic to cite from the book or from the original sources, but citing original source also gives a sense. For example, when we get an article to review, we try to see how many of references has been cited from the primary sources, especially for the issues related to primary source. So if we are reading let's say an article related to Article 19 clause 1 in Indian Constitution, you don't want someone to cite MP Jain or Survey, because it's easily available in the Indian Constitution document. So that is the idea, that citing the original source is much better, and it will also help you to reduce the plagiarism. So that may be good. I hope I answered.
Thank you, sir. That was a great response. Now I request Ms. Vatsal to give vote of thanks. Thank you. Over to you, ma'am.
Thank you, and thank you, Doctor.
I'm unable to hear something if someone is speaking. Thank you. So,
Sir, am I audible?
yes, you are audible.
Okay, actually there was some technical issue. So thanks a lot, sir, for this wonderful session. You enlightened us very well on the topic, research methods in international law. It is very unique and important topic for all of us. Today we gain a lot of knowledge about types of research questions, the intricacies of secondary sources in international law, primary research sources of international law, and many more such relevant topics. Thanks a lot once again, sir, for your precious time and efforts to make this event successful. And thank you all the participants on the behalf of Team Starex University, Gurugram. And now I request all the participants to please go through the feedback link that will be shared in the chat box and on your mail ID also. Thanks a lot, sir, and thank you all the participants.
Thank you so much, everyone. Thank you.
Thanks, sir.